unlawful. And unlawfulness continues to be perpetuated while we are watching. It's very sad. For anybody charged with this sensitive and enormous responsibility. It's like we are being laughed at by SASSA and CPS. It's most unfortunate. And what is even said is that there is no explanation. You know, when somebody has done wrong and they have an explanation to provide that we can all relate to, it makes a lot of difference. No explanation that we can understand has been put before us. It's sad. I just wanted to make that point. I don't think my sister was asking for a comment. I'm not asking for a comment.
No, I understand.
We're just expressing our frustration to your client. Most unfortunate. You assume a responsibility or you reject it on the basis that you don't have what it takes to discharge it. Simple. Anyway, thank you, Mr. Kasim.
Thank you, Chief Justice.
Mr. Kasim, just one thing to clarify.
Yes, Justice.
Is there any particular reason why the relief sought by SASSA was limited to the cash payment extension and not including the phasing in and phasing out that you have made submissions on now?
Sorry, Chief Justice, I understand it. Why is the application limited to that?
The reason that we were given by SASSA for the extension
Yes.
was that SAPO does not have capacity to pay or effect cash payments. SASSA did not tell us that it would require extension as well for the phasing in and phasing out portion of the program so that SAPO can effectively take over.
Justice Jafta, that is really SAPO's responsibility now. We have a contract with SAPO, 1st of April, that's their responsibility. So we one step removed. But I had to point that out to the court because this is practicalities when you migrate from one system to another system. So from SASSA's point of view, we have a contract with SAPO. The one aspect that's excluded is why we are here. The rest is their responsibility from the 1st of April.
But did SAPO say, when the contract was concluded on the 8th of December, did SAPO say it would be in a position to take over the rest of the grants payment, excluding only the cash payments as from the 1st of April?
That is contractually their responsibility. And remember, the advantage with the SAPO contract is that when the money is put into the SAPA account, when it administers it, there's only one deduction permissible, which is your Regulation 28, which is your funeral policy up to 10%. No other deductions. So that's really the differentiating point between the SAPA contract with the SAPO using its bankers, then money paid directly into other bank accounts. But that is SAPO's responsibility from the 1st of April. But on a practical level, your phasing in, your phasing out will not deter SAPO from carrying on its responsibility, provided the recipient changes the card. That's the only point I made. I said there is going to be teething problems.
Thank you, Mr. Kasim.
Thank you, Chief Justice.
Mr. Budlender, are you first or is it Mr. Marcus first or does it not matter?
Chief Justice, I'm older than him and I'm higher on the list. He admits the first.
Very well.
Chief Justice, members of the court, today we find ourselves here again for the second time in 12 months in an urgent application. It's an urgent application which arises from the failure of the Minister and the failure of SASSA to carry out their constitutional duties. It's another last-ditch attempt to avoid a disaster. It is with respect shamefully late, and yet again, for the second time, puts the court in a position where it is faced with a fait accompli. I need to say something about the role of the court in this thankfully unusual situation. These, I submit, are not ordinary adversarial proceedings. They are closely linked to, and in fact part of, the court's exercise of its supervisory jurisdiction when it saw the difficulty. It is part of the court's attempt to ensure that 17 million vulnerable beneficiaries are not harmed as a result of incompetence and negligence on the part of those who owe them a constitutional duty, in the first instance the Minister and the SASSA. And so the court has already necessarily undertaken a more active role in exercising its supervisory jurisdiction than it would do in cases which come before it. It has appointed an expert panel to investigate and make recommendations. That has been the one ray of light in the Surrey saga. And I pause to note, in relation to what my learned friend just said about how SASSA has not dragged its feet. The panel itself says that SASSA has not produced information when requested, has not attended meetings when requested, has dragged its feet, and has obstructed the process of the panel, let alone the process of this court. The core goal of the exercise, I submit, is to ensure that the constitutional and statutory right of the beneficiaries to social assistance, the constitutional right under Section 27, the statutory right under the Social Assistance Act, that it is fulfilled in full measure. That requires protection of the beneficiaries, and that is the part which is the concern of the BlackSash. I want to turn immediately to what is the main risk of harm, the core risk of harm to the beneficiaries for which we submit protection is needed. And it all arises from these dual contracts, the contract with Grindrod Bank for what is called a SASSA branded card, and the contract with CPS for what is called the EPE account. CPS says that these accounts are just bank accounts like other bank accounts. They can be operated just like other bank accounts. It's simply a matter of a contract between a bank and its customer, and no one should interfere with that. That's what's being argued in the matter which is currently pending before the Supreme Court of Appeal, the Net1 case. It's not just an ordinary contract. One needs to look at how the cards and the contracts actually work in practice. We know that contracts are supposed to be consensual, that's the essence of a contract. So how do the cards work? What happens is that when you register for a social grant, you provide CPS on behalf of SASSA with all of your relevant personal information. That is loaded on a SASSA branded card with Grindrod Bank. It's an account held at Grindrod Bank, and it bears the SASSA imprint. It enables you to get access to your money when it's paid into that account at ATMs, through point of sale devices, and at certain merchants. But then there's a second card. The second card is the EPE card. It is a product of Moneyline, and Moneyline is one of the other subsidiaries of Net1. CPS is a subsidiary of Net1. Moneyline is a subsidiary of Net1. They're sister or brother companies. And the way the second, when you register, when you get the second card, your personal information is transferred from your SASSA card to your EPE card by the simple device of putting your finger on a sensor. And all of the information then shifts across. But the result is that the members of the Net1 group have access to your personal information because they have access to the key which operates the EZE, the EPE account. That is explained by Ms. Mart, Volume 3, page A224, paragraphs 25 and 26, and has not been placed in dispute by CPS. Now, CPS says all of this is contractual. This is just another bank account. CPS says that the grant beneficiaries consent to the terms of these contracts, the Grindrod contract and the EPE contract. The BlackSash's attorneys wrote to CPS and asked for information on the means through which beneficiaries are informed of the terms and conditions of these two accounts, which they sign on to by putting their finger on a sensor. And the answer you will find in volume 3, page A241. It's paragraph 3 at page A241. A243, I beg your pardon, is the answer, paragraph 4. And this is what it says. This is now CPS lawyers answering how people are informed. The terms and conditions are currently only available in English and displayed at all enrollment stations. So you see them by seeing them on the wall in English. Continue quote, as part of the process, the beneficiary is prompted to place his or her finger on a scanner to biometrically verify that he or she has received, read, understands, and accepts the terms and conditions. The words, quote, I biometrically verify that I have received, read, understood, and accept the terms and conditions, close quote, appears on the screen. The process cannot continue until the beneficiary acknowledges same biometrically. And one asks the obvious question, what on earth does one expect that the beneficiaries are going to understand by all of this? The contracts you will find at volume 3, page A246 to 247. That's the EPE contract. And volume 3, page A248 to 250, the Grindrod contract. They are, for practical purposes, identical. I want to draw the court's attention to two provisions of this contract to which people agree by putting their finger on a sensor. And I'll use the EPE contract at page A247. First, paragraph 15.1. This is what people agree to by putting their fingers on a contract which they could never have read. If there is a difference between your records and ours, our records will be regarded as being correct, unless you are able to prove otherwise. So millions of people agree to this by putting their finger on a sensor, and they agree consensually, we're told. Secondly, paragraph 15.3, clause 15.3, quote, we may amend these terms and conditions at any time. Publication of such amendments, by such means as we may select, will constitute valid notice of the amendment to you, and such amendments will be immediate effectively. What sort of contract is this, or what sort of consensual contract is this? This is a contract in respect of which huge numbers of people have put their fingers on a sensor. CPS says this is all consensual. We say not. The number of people taking up the EPE card, has rocketed. I'll give the court the references. In February 20th, it's the affidavit of Ms. Mart, it's volume 3, page A230 to page A231, paragraphs 40 to 42. In October 2015, there were 350,000 EPE accounts which had been opened. December 2015, 2 months later, it had almost doubled, 600,000. April 2016, 4 months later, 1,087,000. August 2016, 1,430,000. And last month, in February 2018, 2.3 million. The overwhelming majority are social grant beneficiaries. And Ms. Mart explains why this has been done, and I do want to read this to the court. It's volume 3, page 229. And this also is not disputed. Volume 3, page A229, paragraph 39. Net1 in its media communication, now Net1 is the parent company of CPS, Moneyline and all the rest. Net1 in its media communication, which is attached, was explicit that it will not submit a bid application as engagement with the government. This was at the time that the government was putting out bids after the 2014 decision of this court. It was explicit that it will not submit a bid application as engagement with government, particularly SASSA, is too onerous and risky. It stated that it would continue, quote, providing a comprehensive suite of transactional products and services which will allow it to service all South Africa's unbanked and underbanked citizens, including social grant beneficiaries, but independently and without SASSA's limitations and constraint. The company's business plan includes the continued successful deployment of its Easy Pay Everywhere bank account. The company believes that these activities, now these are the EPE activities, will ensure a sustainable business model that will, over time, far exceed the benefits that could be realized from being the successful bidder for the SASSA RFP. In addition, the execution of the business plan will no longer be limited by a 5-year contract, or potentially shorter if legally challenged, and provides the company with the ability to freely determine pricing that is both competitive and profitable and removes any unknown or contingent liabilities associated with government contracts. So they decided to move out of contracting with government because it was more profitable to set up the EPE cards outside government, was that much more profit could be made that way, and I'll show the court that that is what has in fact happened.
Mr. Budlender, your 10 minutes is off, but I just want to appeal for help from you and obviously from your colleagues as well. As I understand it, there are basically 3 issues that we called upon to decide apart from costs. The first issue is whether or not the protection of the beneficiaries that flows from the BlackSash judgment is adequate, or whether there are deficiencies which justifies rephrasing that order so that it provides adequate protection to the beneficiaries. And the second issue is whether or not this is the right forum, the right platform from which to be asking that an order be made for 700 million rands ought to be paid by CPS back to the state, obviously SASSA. And finally, whether it is appropriate to make the order proposed by CPS that it be authorized by this court to submit such amount as it considers to be a fair reflection of the cost it has incurred to Treasury, and for Treasury to express agreement or disagreement within 30 days of the submission of the amount. I'm paraphrasing, but basically, as I understand it, those are the problem areas, and we would benefit immensely if the submissions by council would be focused on helping us to determine those issues.
Thank you, Chief Justice. I'm addressing the first issue, the problem of protection of beneficiaries, and I'm going to make the submission that the mechanism from which the beneficiaries need protection are the EPE cards, and I'll make a submission as to how that protection can be achieved.
Yes.
So I'm building to that submission.
Is it possible, just in the interest of time, to focus on what needs to be done so that Mr. Kasim and others and Mr. Morrison know exactly what needs to be done to accommodate your concerns and those of Mr. Marcus adequately?
I will attempt to do so, Chief Justice. So, to cut to the chase, as it were, what happened, Dr. Forsland shows, and I'll just give the court the reference, that from 2014, as the uptake of EPE cards increased, the CPS contribution to Net1's profits proportionately decreased. It started at around 40%, now it's in the low 20s. In other words, the profit coming to Net1 is now coming not mainly from CPS anymore, it's coming from the other subsidiaries, and we suggest as a result of the EPE card. Dr. Forsland makes that point. It's volume 3, page A276.
Volume?
Volume 3, page A276 to page A278, paragraphs 44 to 49. What has happened is that the EPE cards allowed the other subsidiaries to get access to the beneficiaries and their information, and so their profits have gone up. CPS has proportionately come down. It's dealt with again by Dr. Forsland in volume 3, page A275, paragraphs 40 to 41, where he makes the point, if I can just read one paragraph. They say, this is what CPS says, or rather what Net1 says, the parent. We created the automatic debit feature to allow a smart card to reduce the balance in any of its active wallets on a specific date and for a predetermined amount. This function can take place in an offline environment at any POS device. The automatic debit feature reduces the risks associated with collection of insurance premiums and other regularly scheduled amounts. Well, it doesn't reduce the risk. It means that there's no risk because you've got the guarantee because the money's there. It does this, it says, by ensuring that any funds loaded to the smart card are first used to service the automatic debit before being transferred for the cardholder's general use. So that's the mechanism. It's explained also by Ms. Mart, volume 3, page A223, paragraphs 24.2 to 25. She says that the loading of the beneficiary's information gives access to this information to all the entities in the Net1 group, and that's not denied. But people do sign, they sign in increasing numbers, from 350,000 to 2 million. And one can only guess how many more there will be if the CPS contract is now extended for a further 6 months. The point made by Net1 in the passage that I read is that these aren't customers for the duration of the contract. They're permanent customers because they're now on your books. You've got all their information, you've got access to it. It's the gift that keeps on giving. Even when CPS exits, if it does in 6 months' time, you've still got the 2 million people on your books. So why do people sign on? CPS says because the product is marvelous. Beneficiaries say, or some of the beneficiaries say, that officials tell them that the green card is the new SASSA card. Some of the officials, they say that they've been told that you have to have the green card to get your grant.
Mr. Budlender, I'm sorry. How can the deficiency be cured? How should we structure the order in order to provide beneficiaries with optimum protection? We appreciate there are problems, but can you cut to the chase, as you said?
I'm sorry, Chief Justice. The answer, Chief Justice, lies in the regulations which the Minister made, which are in Volume 9, page C85. And what those regulations say, it's Regulation 21.1, if I can just get it. It says the agency shall pay a grant A into a bank account of the beneficiary or institution where the beneficiary resides, provided that the beneficiary of the social grant consents to payment in accordance with 21.1A in writing and has submitted such consent in person to the agency. So you can sign on to a bank account and then it's paid into the bank account, but you must sign on and you must present that to SASSA. Now, that doesn't happen when a beneficiary puts his or her finger on the sensor, with the result that the grant money is transferred into the EPE account. And so the expert panel has recommended to the court that this be regularized, and has recommended, I'll give the reference, it's the third report, volume 8, page B326, paragraph 6.6, and it's dealt with further in volume 8, page B296, paragraphs 3.1.9 to 3.1.11. What the expert panel recommends is that this be regularized by people being required to give written mandates to SASSA saying that they want to transact through a bank. It's also what SASSA says it wants to do and has started doing, and they will find that in volume 12, page C372, para 3.3.2c. And so that, Chief Justice, is the solution to the problem of EPE accounts. The beneficiaries who want it must sign up for it, as the regulations require. That's what the panel recommended, and that's what we ask the court to order. In our affidavit, we suggested a moratorium on the issuing of new EPE cards. On reflection, that may be less effective than something which regularizes all the EPE cards and makes them subject to the regulations. There are two qualifications which are needed and which I need to explain to the court.
And before you come with the qualifications, before the thought escaped my mind, would you and Mr. Morrison and Mr. Kasim, during the break which will follow at the end of your submissions, see if that's something that you can agree to? Whether that rephrased order in order to provide optimum protection can be agreed to by the
You'll be
parties.
delighted, Chief Justice.
Yes.
So the two qualifications are the following. Firstly, where there's an existing EPE card, you can't simply stop paying into the card because the beneficiary will arrive at the end of the month not knowing anything about it, put the card into the machine, and no money will come out. And so what we submit is that the order should be, what the court should direct, and I'll raise it with the learned friends, that there may be no deductions or debit orders from the EPE card other than cash withdrawals unless the SASSA has been given a written mandate by the beneficiary to pay to the bank. What that will mean is that the grant will continue to come in until it's all put on a proper footing. People will get access to the money, but that will be the end of the matter. And that, of course, will be a temporary arrangement because in due course, so we believe, everyone will receive a SAPO card. The grant will be paid, and the EPE cards will then not receive the grant payments. The second qualification is that the order of the court will need to be explicit in this regard, and I need to explain to the court what the difficulty is. The regulations deal with the account into which CPS on behalf of SASSA makes payment. And if it's a bank account, there must be a written mandate. Now, there's some dispute as to what happens when you've got an EPE card. Does the money come into the Grindrod account and then go out to the EPE account, or does it go directly to the EPE account? And there's a dispute about what the mechanism is. And we say that either way, both of those must be covered. It's paid directly by CPS, the paymaster, and it should apply whether it's paid directly into the EPE account or via a Grindrod account.
Just to make sure I understand the first point, does it relate to all deductions, irrespective of who the money gets paid to, who the deduction goes to?
Yes, Chief Justice.
What if it's a genuine transaction between the recipient and an insurance company, and people just want to be insured in case they die?
Because, Chief Justice,
is it not going to result in an unfortunate and unintended termination of an otherwise valid and legitimate insurance, policy?
Well, it would be possible for the court to carve out a separate dispensation for Net 1 subsidiaries and say this applies only to Net 1 subsidiaries because they are the sisters and the brothers of CPS and they can deal with the situation, and others shouldn't be affected. But that's a more limited form of order. In principle, it should, we submit, be the default position, that without a mandate, you don't get payment. But I understand the point that the Chief Justice is raising. We submit that if this mechanism, which is the mechanism recommended by the expert panel, that now all of this must be validated through a mandate, a written mandate, if that's implemented, grant beneficiaries will be substantially protected against exploitation or overreaching. It will not be perfect protection, but at least we will know whether the 2 million EPE holders really want an EPE card and all that goes with it, because they'll have to sign on properly. And they'll have to sign on under supervision of SASSA, which will presumably explain to them what they're signing on to. Moneyline will then have to do what any commercial bank has to do, sign up the client with a proper written mandate. It will level the playing fields. All the banks have to sign up on the same basis with a written mandate. And we say just applying the rules to the EPE cards will provide substantial protection to grant beneficiaries, and the court, the submission is that the court should therefore order that Regulation 21A1 will apply to the EZE accounts whether the money came in directly from CPS or whether it came in from CPS via a Grindrod transfer. Chief Justice, those are the main submissions I want to make. The two other matters I'd like to deal with briefly, if I may. There are two other problems which need to be addressed as far as protection is concerned. The first is the recourse and grievance mechanism for people who have difficulty with the system. I'm not going to go into that. It's dealt with in the papers. The expert panel has found that the current system is, quote, wholly inadequate, close quote. And you'll find that at volume 8, page B285, paragraph 1.2.1. And it's further discussed in volume 8, page B297 to 300. CPS says there are no problems. It all works terrifically. This is, of course, a systemic issue, and it's quite a simple thing to test. All you've got to do is send somebody to one of the pay points, send somebody with a problem, let them try to phone CPS, let them try to phone Moneyline, whoever. It's a very simple thing to test. And we ask that the court request the expert panel to investigate the matter as to how the recourse mechanism works from the beneficiary's point of view, and to make recommendations as to how it should be improved if it considers that necessary. This Chief Justice is likely to be an ongoing issue. It's not just a matter for the next 6 months. It's a permanent issue which needs to be now properly put to bed. Has never been put to bed. The second
is SASSA keen to address it, because we may be burdening them with something that as SASSA is willing and able to do.
Well, the first thing, Chief Justice, with respect, would be to find out how does the system work and what are the defects in it, if any. And if proposals are made, no doubt the court would want to hear from SASSA, from CPS, or anyone else before any order was made. This is really a fact-finding exercise and getting a recommendation from experts. The second issue is, as I said to Chief Justice earlier this morning, I said I wanted to say something for 2 minutes about the question of profits. I'm not going to enter upon the debate about whether there should be profits, if so, what sort of profits, should there be pay back the money, any of that. I'm just wanted to say 2 minutes about what is a profit. The fact, as one knows, and as Dr. Forsland has shown, is that CPS now contributes about 20% of the profits of Net 1. The bulk comes from two sources. It comes from what CPS pays to Net 1, its parent company, licensing fees, fees for services. Those are the things which are always vulnerable to transfer pricing. And secondly, it comes from the profits made by the other Net 1 subsidiaries, Moneyline, Mangia Mobile, and Smart Life. Smart Life provides funeral benefits. We were told in the Pretoria High Court that it's only funeral benefits for grant beneficiaries. It seems to be a profitable business. Those subsidiaries would not receive these benefits if it was not for the unlawful contract. If it weren't for the unlawful contract, there wouldn't be the EPE cards, and they wouldn't have access to this information and access to the beneficiaries. They've built their business on the back of the unlawful contract, which has been continued in operation out of necessity. And so we say that perpetuating the unlawful contract necessarily perpetuates the situation that the other subsidiaries will make their profit, and it will of course continue even if the new contract is not extended, but I'll leave that for the moment. So in all pay 2, this court required a full disclosure of CPS's income, expenses and profits under the invalid unlawful contract. We submit that the same should apply when whatever order is made in that regard to the profits of CPS's fellow subsidiaries. They only made the profits because they are fellow subsidiaries and the CPS unlawful contract has been extended. And that's just an accident of company structure. If all of the work was done by CPS, then all of the profit would find its way into CPS. Instead of doing that, the work is done by 4 different companies. It finds that the profit finds its way into 4 different companies, all of it into the hands of Net 1, the holding company. And so we submit with respect that any accounting for and investigation of profits must include the profits of the other Net 1 companies which transact with beneficiaries and derive profits from those. Those, Chief Justice, are our submissions.
Just one question, Mr. Budlender, but none of those entities are before us.
No, but the court can order an investigation into what's going on without making any order against them. The court can say, when you find out the profits, find out what the profits are of the other companies, And obviously, all of this will have to come before court for a decision, this court or another court for a decision as to what, should there be a disgorging of the profits, what are the profits. Those parties can then be party to the exercise. This is just a fact-gathering exercise.
Advocate Budlender, do you accept that in the event of the extension of the contract, that the amount of 1644 per beneficiary will substantially increase in respect of the cash services to be provided by CPS as suggested by CPS?
Yes, I can't, we don't have the facts as to the numbers, but it's logical that the most expensive part of the service is putting cash in a security van, taking it out to the people and having security people and others there. That must be the most expensive part of the service. You would expect that that's the most expensive, and the least expensive is what SAPO are generously doing for R6 something. That's actually the easiest and the least expensive part, what they're doing. Thank you, Chief Justice.
Thank you, Mr. Budlender. The court will adjourn for about 15 minutes.